Hi, folks. We're just gonna give it just one more minute to let people join us, and then we're gonna get started soon. Okay, I know folks are still coming in. Our coworker Yvonne is on the chat, and we'll keep an eye out for who else to admit. So welcome. I hope everybody can hear me okay. Thank you so much for joining us for this CLE. We're focusing on sexual assault protection orders. Before we get started, just a couple of housekeeping announcements. So first of all, we're recording this to be able to make this available, to any of you who want to go back and review this recording, if you find this material helpful. And we'll be emailing this out to everyone at the end of this week. We also have this PowerPoint available that we'll be emailing out to folks as well. And I think Yvonne, our coworker, is going to be uploading it into the chat, so you have immediate access to it if you do like to print it out and follow along. Because we are recording this, we're asking everybody to stay on mute. There are going to be opportunities to be able to actually provide some feedback and ask questions. But we do ask that if you do have questions, if you can put it in the chat, or comments, if you can put it in the chat, and we'll definitely be moderating that. And I think, oh yes, and the last housekeeping is that we are gonna send out a survey. We're gonna post it in the chat about 10 minutes before the end of this presentation, because filling it out allows us to include your information, send your information to the WSBA for CLE credits. We will also send out the survey with the PowerPoint at the end of this week, with the PowerPoint and the recording at the end of this week, in case you do have to leave a little early, so that you can get CLE credits. That's it for housekeeping. Is there anything I'm missing, Sarah?
I need to unmute. I don't think so, Rudy.
Okay. So welcome to our Lunch Matters CLE focusing on sexual assault protection orders. A little bit before we jump in to the presentation, a little bit about me. I'm Reedy Mukopade. I am the director of the program and have been with the program for almost 9 years now, a former public defender, and prior to that, immigration attorney with the Northwest Immigrant Rights Project. Before law school, I was also a DV and sexual assault advocate. And then I am actually co-presenting with my colleague, Sarah Mooney. Sarah, do you want to introduce yourself?
Sure, my name is Sarah Mooney. Like Reedy, I also have a public defense background. I've been with Sexual Violence Law Center a little more than 3 years at this point. So I'm glad to be here.
Sarah is so much briefer than me. So we also wanted to know who all is here with us. And so we just have 2 poll questions that hopefully you can see. And if you can just take about 30 seconds to fill this out, so we all know who's in the room with us. Are folks seeing the poll?
Yep.
It doesn't look like, or I hope folks are actually able to answer. Let me see, I'm gonna end the poll now and let's see what the results are. Usually I can see if folks are, doesn't look, maybe it's showing on your end. It doesn't look like anybody took the poll on my end. So I'm not sure how that's looking for everybody else.
I can share, I see the poll results.
Oh, can you share it, Yvonne?
Yeah, I see. So for advocates, we have 11 folks, 23%, and attorneys who work mostly with survivors, 20 folks, 43%. Attorney who works mostly with respondents, 2%. Attorney who is new to these types of cases, 19%. Judicial officers, 4%. And working with survivors in other capacities, 4 folks, 9%. For the question, have you experienced domestic violence, sexual assault, sexual harassment, or stalking? 31 folks said yes, which is 66%, and 16 folks said no, which is 34%.
Okay. So thank you for sharing. Welcome everyone. And the last question is also just a reminder that we do have survivors always around us. Many of us identify as survivors. So with our questions and how we talk about these cases and how to handle sexual assault cases, to be thoughtful and mindful of the language you use. And of course, if any of this information you might find triggering, please do take a break. This is why we're also recording this, so that you can always refer back to this later when you are ready. So a little bit about us. First of all, we are doing the CLE series in partnership with the South Asian Bar Association of Washington. We're very excited to have them partnering with us, and we have some members of SABA on this training as well, as audience in this training, and we hope that we'll be collaborating with you on cases, and look forward to pro bono assistance from our SABA members. And then Sarah, do you want to talk about the program itself?
Sure. So we are a civil legal aid program, and we are holistic in our services to survivors. So what that means is we try and handle as many, if not all, of their legal issues as possible. So those can include issues in the criminal justice system, Title IX education issues, issues with employment, housing, immigration. You can see the variety of legal areas that we practice in. We at least provide consultation and advice on all those areas. There are a couple that we specifically do not offer direct representation for, and that is personal injury and family law. We have, I think I touched on this a little bit, we have sort of three tiers of service that we provide survivors. So we have litigation, which again is direct representation, which most commonly looks like entering a notice of appearance on behalf of a client in a case. We also do just consultation and brief services, as well as legal line, which is a statewide phone number that anyone can call, survivors, survivor support, advocates, other attorneys for technical assistance. It's manned by the lawyers in our group. So when folks call, they're immediately connected with an attorney. We say it's a statewide legal line. We get calls actually from all over the country. We also do advocacy. So we work on policy reform and legislative reform. We often are testifying on behalf of important bills for survivors. And then education, like the CLE that we're doing today, as well as community outreach.
Thank you, Sarah. And we serve both adults and children, and we also serve survivors of all gender identities and sexual orientation. So with that, actually, Sarah, do you want to jump into talking about the Sexual Assault Protection Order statute?
Sure. So we'll start with a really strong statement by the legislature regarding their intent behind the statute. They've acknowledged and recognized that sexual assault is the most heinous crime against another person short of murder, and that it inflicts humiliation, degradation, and terror on victims. So the intent of this statute and the process of obtaining a civil sexual assault protection order was created to be a remedy for victims who don't qualify for a domestic violence order of protection. And it was also established in recognition that victims and survivors can't always get protection that they need through the criminal justice system.
So the legislative intent really identifies how traumatic a sexual assault is, and it's important to understand what trauma is if we're going to talk about sexual assault protection order and representing a sexual assault survivor. So specifically, it can be a single event or a series of events that end up having causing serious harm to an individual or a community, and that has lasting adverse effects. And we also think about trauma not just as an individual, as event itself, but also think about how trauma can be compounded by other identities and experiences that a survivor might be having. And so just here as an example, sorry, I love animating things. Often survivors, different identities. So because a survivor may identify as non-binary, maybe the same survivor identifies as a person of color, maybe they also have a disability. All those different identities can often further compound the trauma that a survivor is experiencing because of microaggressions or discrimination related to those identities. Often with many of our survivors that we work with, there's been past abuse that further exacerbates the trauma. There have been mental health issues, or maybe because of the PTSD they're experiencing, that complicates how the survivor is able to navigate the legal system. We live in a victim blaming culture. Often the focus has been on the survivor's conduct and the survivor's behavior instead of focusing on the offender. And this is often really traumatic and painful for the survivor to have to experience when they're coming forward when talking about a survivor. Lack of community support, lack of family support, a hostile legal system that we're constantly trying to help survivors navigate, limited resources, and then always the intersection of misogyny and racism when we're talking about sexual assault. So these are just some other aspects of trauma to keep in mind when you are working with a survivor of sexual assault. And how does this play out? Sarah, do you want to take this one?
Sure. So as I think most of us know, given our experience with the legal system, it can be a very complex and intimidating experience, particularly for pro se folks. And then, you add to that trauma that these survivor clients have experienced and are experiencing. So it's important to look at and acknowledge the reality of trauma. So what does that look like from your client? Well, it can look like a very flat affect or a blank stare. It can be the opposite. The person could be very emotional, unable to focus. They may be agitated and irritated. They may feel anger about what's happened and what is happening. They will likely be confused. Again, this is not only confused about the process they're going through now, but perhaps even confused about what has happened to them and what sort of options that they have moving forward. They may seem nervous. They may exhibit nervous behavior. They may minimize the abuse that they experienced. And they may laugh or make jokes, which I think is not an uncommon coping mechanism that people have with stress and trauma. So looking at those, I guess, sort of exhibited behaviors, you can see how those could be problematic in the legal system, where there are very specific expectations and demands of the people who participate in it. They want to know what happened, and they want to know it linearly, that's a word, and chronologically. They want to know who, what, when, where, how. They want the story to be fact-based. They don't want emotion. And I keep saying they, and I'm talking about the systems and the gatekeepers and people in those systems. They don't want emotion. They just want to know what happened. They want people to be respectful to everyone involved. There are, again, very complex procedures involved in the legal system, and there's an expectation that you be aware of what those are and that you know how to navigate them. And then they want legal language used. So as the attorney and advocate for this client who has experienced and is experiencing this trauma, it's really your role to not only help your client be able to navigate that legal system while they're experiencing these things, but also to educate those systems and the gatekeepers of those systems as to why there needs to be a little flexibility in how folks are allowed to participate. And that goes into, that's one piece of having a trauma-informed practice. And I think I spoke about our program being holistic. We also focus on being trauma-informed and client-centered, and we're going to talk about that as well. Do you want to go ahead, Reedy?
Sure. So when we talk about trauma-informed, it really is about adapting your advocacy to the survivor's needs instead of expecting it to be a one-size-fits-all, because people's traumas present and manifest in different ways. Often we see attorneys feel very uncomfortable with responses that a survivor may have from trauma, but it is really important to affirm the survivor in their responses. So, if they are getting really upset and angry, and then they're apologizing for being so upset, letting them know that's actually completely okay. It's a normal response to feeling maybe betrayed by the system, feeling betrayed by an abuser that they trusted, or if they're crying and they're apologizing for getting so emotional, letting them know that that's okay. These are all normal responses to trauma. a part of trauma-informed practice is to be aware of the legal system and systemic re-victimization that survivors experience, and preparing them for that, and acknowledging when the system is re-victimizing them. So, for example, I've seen in court, after a judge has said some really terrible accusatory, maybe has engaged in some victim blaming. I've overheard attorneys then talking to their clients saying, well, the judge is actually a really great guy, they have to be neutral, and then really diminishing maybe what the survivor's experience is in that moment, and not unwilling to acknowledge how misogynistic sometimes the court can be, or racist the court can be, depending on who the judicial officer is that you're in front of. Paying attention to not using victim blaming language ourselves, and then always listening with care, making sure it's a conversation, not an interrogation, not jumping straight into the who, what, where, when, how, that Sarah was talking about in the previous slide. And we always want to give survivors choices, and really have their consent in how we're advocating for them, so that for them, it doesn't feel like another betrayal. Related to thinking about trauma, because we do have ethical duties to our clients as an attorney. 1.1 is really, really basic. And we're talking about the RPCs because this CLE also, there is ethics credits associated with it. But it is important to remember that competence is a combination of, these 4 aspects of the legal knowledge. So actually understanding the statute, skill, actually having the skill to be able to engage with a survivor, being prepared and being thorough in your case preparation, and how you're representing the survivor. But we also wanted to draw attention to RPC 2.1 because this specifically also mandates a duty on attorneys to not only rely on the legal system and the law, but also to be an advisor related to other factors, social, moral, economic, political factors. And when working with survivors, this is where it's really crucial that we be talking to our clients about rape culture, trauma, and victim blaming, and other aspects that a survivor needs to be aware of, and when they're engaging with the legal system. So we're now going to just jump into the actual filing and process of a sexual assault protection order petition, and how you would litigate that. So Sarah, do you want to talk about eligibility?
Sure. So how do you know if your client is eligible for a sexual assault protection order? There are a lot of protection orders available. So first of all, there is no statute of limitation, so that doesn't need to be a concern. I think I mentioned before that you need to not qualify for a domestic violence protection order. That seems to be the most common confusion that we see. If you qualify for a domestic violence protection order, that's what you need to petition for, even if the assault being described is a sexual assault. So the assaultive act that needs to have occurred and needs to be pled as part of your petition is at least a single incident of non-consensual sexual conduct or sexual penetration. And we're going to talk a little more about exactly the definitions of those statutory elements. So who can file? The survivor victim may file, or someone may file on behalf of a survivor victim who is either a minor, a vulnerable adult, or any other adult who cannot file the petition due to age, disability, health, or inaccessibility. Where to file? You file in the county where the survivor lives, the petitioner lives, and you can file in Superior District or municipal court. and there is no cost, there's no fee to file for sexual assault protection order or to have law enforcement serve those initial filed documents. So here are those more sort of specific definitions, and this is really the key to your case. This is where your focus as the attorney needs to always come back to. So non-consensual. Non-consensual is a lack of freely given agreement. So that means it does not require an expression of refusal, just an absence of affirmative consent. Silence is not consent, and this is something that comes up often in every case, particularly in the responses that respondents offer. I think that Yvonne put in the chat a link to a video that we would have liked to have shown, but limited on time. It's funny, but it's actually really helpful and illustrates what consent means. It's comparing it to offering someone serving someone a cup of tea. So I recommend everyone take a couple minutes to watch that. There are situations where someone has an inability to freely give agreement. That can be based on their age, that can be based on intoxication, disability, or coercion by the respondent. So I had just mentioned one of the barriers to being able to consent, and that was intoxication. There's a case, Nelson v. Duval, that says the ability to consent requires a person to have the capacity to consent or freely give agreement. This was a case that one of our pro bono attorneys appealed, where the petitioner for a sexual assault protection order testified to having consumed a significant amount of alcohol and having no memory of the night and not remembering consenting to sex. And the Court of Appeals found that the trial court erred as a matter of law in failing to consider and find, based on the evidence, whether the petitioner had capacity to consent. So if there is evidence of excessive alcohol consumption or other impairment presented in your protection order matter, the trial court has an obligation to determine whether the petitioner, your client, had the capacity to consent or not.
And the way this often plays out related to protection order is we talk to clients about not being embarrassed or not being afraid to share how intoxicated they were, because obviously there is a lot of shame and self-blame that a survivor might be experiencing related to the sexual assault. So not only looking at how much the client drank, or who had access to the client's drink, or what other drugs or intoxicants the survivor may have consumed, but also really looking at the respondent too. How much did they drink? Was your client drinking maybe for every 3 glasses of wine, the respondent had a beer, because this is where it also helps when you're talking about consent related to intoxicants. Often what we're identifying is that the survivor was did not have the capacity to consent in comparison to the respondent, who often is in better control or is specifically using alcohol or an intoxicant as a weapon to make the survivor further vulnerable. Sexual conduct. So the SAPO statute is very specific in what they identify as sexual conduct that would meet the definition of a sexual assault if there was non-consensual sexual conduct. Unlike the domestic violence protection order, which talks about domestic violence, stalking, sexual assault, but it doesn't necessarily go into very clear definitions. Stalking also, it's not like it goes into necessarily the clearest definitions, but of all the protection order statutes, I think the SAPO statute is probably the most exact in its definition about what meets the criteria for a protection order. And so we have the definition available at 790.010, and it's actually 7 definitions. This is just a very concise description, but it's any intentional, knowing, touching, or fondling of the genital, anus, and breasts of the petitioner, and it's over clothing or under clothing. So this is sometimes for some folks, they may think that they were not sexually assaulted. They feel like they were assaulted, but because it was over the clothes, they without knowing the definition of the law, they may think like they don't qualify for a protection order, but it's over the clothing and under the clothing. It's also any exposure, coercive exposure, intentional exposure of the victim or the respondent's genital, anus, or breast for sexual purposes. So this is an area that I think, especially in alcohol facilitated sexual assaults, where the survivor may have no memory at all of what exactly happened, but knows that there was some sort of sexual contact. Often if they're waking up with maybe their clothes off or they've been undressed, this definition meets that definition of sexual assault. The definition for sexual conduct also identifies contact related to children, preteen, meaning under the age of 13, any touching of the body, unlike adults where the focus is genital, anus, and breasts. Any touching of the body for sexual gratification of a preteen is considered, can be considered a sexual assault, or making the preteen touch the respondent's genital, anus, or breast. So that's not the general body, but the genital, anus, and breast. We've had questions. We have people contact us often about, somebody forced a kiss on me. Is that a sexual assault? It may be unwanted contact, but unfortunately for the sexual assault protection order, it does not meet the definition because the language is very focused on genital, anus, and breast. Another example is, a coworker maybe slap somebody on their butt, and maybe it could qualify for anti-harassment if there's been a pattern, but unfortunately for sexual conduct, it does not meet the definition. The reason for this kind of narrow definition is also to avoid situations where, maybe I don't know if anybody has gone streaking in college or as a part of any sort of hazing process, but that doesn't have necessarily a sexual intention. And so just because you saw somebody streak across you, that doesn't mean that you experienced a sexual assault for the purpose of a protection order. So understanding the definition of a sexual assault really helps identify for a survivor whether or not a protection order is appropriate for them. And then, Sarah, do you actually want to talk about penetration, which in some ways seems the most obvious, but it's also helpful to discuss?
Yeah, I think kind of just like with the sexual conduct, it's just incredibly important to review and be very aware and familiar with how the statute lays out the definition. And again, for your client, I think something that we find is that there is sort of often a common assumption about what sexual penetration is and what it involves. And it's actually, I think, broadened by the statute. So any contact, however slight, between the sex organs or anus of one person by an object, a sex organ, mouth, or anus of another person, and any intrusion, however slight, of any part of the body of one person or of any animal or object into the sex organ or anus of another person. So including cunnilingus, fellatio, and anal penetration. And then evidence of emission of semen is not required for a finding of sexual penetration. So again, I think it's just very important to make sure that you look at these definitions and really understand them, so that when you're talking with your client about what they experienced, you're able to ask the questions that you need to in order to make sure what occurred fits within the statutory definition. So we'll go ahead and start with how you get the case started. So the first step is preparing the petition, and the petition is a standard court form, which is available to anyone. The burden on your client is preponderance of the evidence, and case law basically defines that for us as just more likely than not. In talking to clients, that's how we'll describe it. I'll also sometimes just describe it as 50.00001%. The petition alone can be sufficient for the court to make a finding of sexual assault and issue a protection order. It can be supplemented with an amended petition if the respondent has not yet filed their response. And then it can also be supplemented with just a declaration by your client, by the petitioner at any time. Again, you want to make sure that petition specifically states facts adequate to make that prima facie case. I just mentioned talking to your client to find out, to really understand what they experienced and to find a way to match that to the statutory definitions. Always kind of turning towards being trauma-informed and client-centered. You want to, as much as possible, you want to minimize how much you're having your client, making your client talk about what happened, because every time they're talking about what happened, they're reliving it. And that just conversation with you in and of itself can be incredibly traumatizing. So be thinking about ways that you can get the information that you need in order to create the best case possible, but also minimize the potential harm that talking about that with you could do to your client, whether that's working with an advocate who maybe has already talked with the client about what happened. Perhaps there's other documentation somewhere where the client provided information as to what happened to them. It can be very uncomfortable preparing the petition for a client. This is obviously very private, very embarrassing information for them, although obviously they have nothing to be embarrassed about. But it is really important to let your client know that the more detail you can give in the petition, the stronger your case will be, and the more likely it is that the court can apply, that detailed account of what happened to the law and find that they qualify for an order. Also, we'll talk a little bit later about what a final hearing looks like. But the more detail and information you can provide in the petition and the written pleadings, the more likely it is, or the better chance your client has of maybe not having to provide testimony or talk about what happened to them during the hearing, which is not something that, at least in my experience, my clients are wanting to do. On the petition, you're stating the relief that your client would like. You can think outside the box a little bit on this. If you don't ask for it, you won't get it. So, for example, on the distance restrictions, 500 feet, always, checking the box for school, home, work. You can also ask that that distance restriction be applied to the petitioner's person, to locations where they commonly are. Perhaps your client volunteers regularly at a particular location. Maybe your client's child is involved in some sort of a sport or activity that puts them in a certain public or community space on a regular basis. And then you can also include the person's vehicle, your client's vehicle. If the parties are minors, there is an opportunity to request a school transfer for the respondent. I think all of our experience is that the court will order that. It's not, I don't think it's something that it's something that you need to be able to make a case for. And then the duration of the order. You can ask for the order to last as long as you want. You can request that the order last a lifetime, and we've certainly done that. And in some situations, we've had orders that the court issued for a lifetime. But just be prepared to provide a basis and a justification for why you're seeking the duration that you're seeking. But it's certainly not limited to 2 years. And then keeping in mind privacy concerns. Again, unfortunately, your client is having to disclose this very personal, very private information. And sometimes your client is a minor. So depending on the age of the minor client, their level of participation, personal participation in the case, you can think about maybe trying to use initials when referring to them, and just finding ways to protect as much as possible sort of their privacy and identity in the case. And then thinking about that with exhibits. Given the conduct that's at the center of these cases, there may be explicit images or explicit text messages or other communications that would be very compelling in your case. And so it's important to talk with your client and weigh sort of the value of those things to your case with the disclosure of those things to the court, to the respondent, and really potentially the public record.
So what does initiating a case look like? You filled out the petition, you've talked to the client like Sarah was talking about, you've talked about what kind of evidence there is. So now you're ready to file. So the first thing is you file ex parte in the county that the petitioner resides. So this isn't where is the respondent or where the petitioner works, but where the petitioner resides. And actually, SAPOs can be filed in Superior Court, District Court, or Municipal Court. But be thoughtful and strategic when working with a survivor, with a petitioner, about where they want to file. So, for example, if in your county, a majority of sexual assault protection orders are heard in Superior Court, that means that bench, that judicial officer, is going to be more familiar with that process. And more familiar with the statute. So it may make sense to file in Superior Court. Maybe District Court or Municipal Court is closer. So it really depends. But if youth are involved, Superior Court is where you should be filing the petition, especially around school transfers and things like that, which, by the way, school transfers are not always granted. They're not automatic just because a protection order is issued. Often there's a separate sort of balancing that the court is doing to see what kind of interruption a school transfer would cause for a petitioner and a respondent. So filing an ex parte when you do file an ex parte court, so by ex parte, for anybody who's not familiar with court, ex parte means like the other side isn't necessarily present. Your hearing is going to be set out 14 days. This is required by the statute that it be set out maximum 14 days to allow service and notice to the respondent, to the other side. So it's really important to also talk to your client about timing, because if you're thinking, well, I'm going to take the next 3 weeks off, or I'm going to take the next month off, and then you're going to end up with that initial hearing 14 days out. Maybe you have to talk to your client about it, maybe delaying the filing, or being aware that they're going to have to come back and ask for a continuance. And at the filing for the 14 days, often if the at least prima facie case is made, a temporary order is granted during that intervening time, and it will continue to be extended unless the court has reasons not to extend the temporary order until there's a final decision in the case. When a temporary order is not issued, the court is required to put in writing why it's not issuing a temporary order, but it's still required to also set a hearing out. So just because at the time of the filing, a judge may think that there's not enough here for a temporary order, that doesn't mean that the petition just goes away. There is still a final hearing that the petitioner is allowed to have to determine if a final order should be met. And that's also the opportunity to supplement information and add information to the court record that will hopefully help make a final determination on the protection order. And the last thing to keep in mind related to filing is notice and service to the respondent. So if I file the hearing, if I file my petition and it's 2 weeks out, so 2 weeks out on a Thursday, and the respondent gets served the day before, the Wednesday before the hearing, that is not enough notice to the respondent. The statute requires at least a minimum of 5 days notice to the respondent before the hearing. So the case will the case will get continued unless, and I've never, well, actually I have had this happen a few times where the respondent has just come in and essentially waived notice and said, I just want to get this done. But often the court, out of abundance of caution, will often still continue the case just to give the respondent adequate time to prepare. In the past, what used to happen is there would be multiple attempts to serve a respondent, and if you couldn't find them, or if they were avoiding service, the only option a survivor had was to then serve by publication, which can be really, really expensive. In the last 2 years or 3 years, the statute's been changed to now allow service by mail, but you have to show that service has been attempted and why it's failed. And thanks to the governor's orders, because of the pandemic, now electronic service is also permitted, though we will see in the long term if that will continue, if that will still be allowed in the long term. Sarah, do you want to talk about preparing the case?
Yeah, and I just was going to say on that notice to the respondent, I believe it's 5 court days too, so that can make a big difference.
Yes,
so.
5 court days. And the other thing that reminds me, hearing being set 14 days out, also pay attention to your specific court process. So for example, in King County, sexual assault protection orders are only heard on Tuesdays. So even if you file it on a Thursday thinking it's going to be 14 days out, it's going to be heard 12 days out in that case, because it's going to fall on a Tuesday. Snohomish County, every county is a little different. A lot of other counties don't have specific dates. I know, like, for example, in Snohomish, we hear them any day of the week. But also pay attention to your local jurisdiction and when they and how they schedule these hearings.
And then, sorry, do we go until 1 or 1:15?
We are going until 1.
Okay, well, I'm gonna speed up. Try and speed up a little bit. So preparing your case. So evidence. So first of all, this is a special proceeding, and so the typical evidence rules need not apply. So good evidence can include hearsay, and a court can make a ruling based on the documentary evidence alone. Testimony is not required. Declarations by your client as well as third parties may be helpful. Again, you want to always have your scope narrowed in on the elements, the non-consensual, the sexual conduct, or sexual penetration, and you want your evidence to directly assist in proving that occurred. It could include photographs, screenshots of communications, text messages, or communications through social media between the parties, photographs of injuries if those exist, photographs that establish the parties were together or in the same place at the time the petitioner has stated the sexual assault occurred. Prior communications with the respondent or communications after that may very well amount to admissions. We've seen that before where respondents have acknowledged or apologized for the conduct. Law enforcement reports or charging documents. Charging documents, obviously, those are public documents. The caution there is really with the law enforcement reports. Hopefully the law enforcement reports you're receiving have been appropriately redacted, but they aren't always. So I would always review those reports before you file them. Addresses, phone numbers, other identifying information does not need to be included. And then medical or mental health documentation or letters of support from a provider, a counselor, a therapist. Again, all of those things can be very compelling, very helpful to your case, but they also are typically privileged. That's typically privileged information. So it's, again, weighing with your client the benefit and help that may have in your case, and then compelling the judge to find those elements met and issue that order, with the fact that now that information is being disclosed to the respondent and perhaps respondent's counsel. So it's just balance, again, just kind of balancing the weight of that evidence with the privacy that's being given up as a result. And then witnesses, who do you ask? Just kind of like with other protection orders, your client may know 100 people who know that this guy has an alcohol problem or abuses drugs or is just generally a jerk. But that, again, does that really go to the question of whether a sexual assault occurred? So just being mindful and deliberate in terms of the evidence that you're presenting.
And also related who to ask. Sometimes there may be folks that may be a really great witness, another past victim, somebody else who's aware of the course of behavior that the respondent engages in, but your client may not feel comfortable actually having more people involved because of the fact that this is talking about a sexual assault. So also being mindful of those privacy concerns that a petitioner might have. So with the pre-hearing and often during the hearing, just be prepared. Let your client know that these are some of the common responses we often see with respondents. You know, that it was completely consensual and the survivor is now changing their mind, or that there's something mentally off about them, or they're completely jealous because the respondent has such a great life, and this is the way the survivor is going to get back at them, by going through this really public and humiliating process. It makes us laugh. It also makes us cry. How often we see respondents say, oh, they've moved on, so they don't understand why the survivor hasn't been able to move on, and what's the big deal about the petition? Why are they now trying to get a petition? And then another common response we've seen is that since the sexual assault, there hasn't been any contact, and that the respondent has no intention of contacting them again. So that's one reason why the protection order shouldn't be issued. It's helpful to let your client know to expect potential responses like this, because it prepares them when those responses are actually filed. And for a lot of clients, I think it's also really shocking because they feel like the respondent is lying. And I think for some folks, it just feels really, really shocking that they can maybe outright lie to the court. So it's just helpful to prepare your client in saying, you know, these are sort of typical responses we see. And it's just good to know that this might be coming down the pipeline. We also wanted to focus on linguistic power that each of us have as attorneys, as judges, as advocates. We carry a lot of power in how we talk about a case and the kind of record we create for the public. And for survivors who may be listening in on that case in open court. And so it's really, really be paying attention to the blame shifting that happens, the minimizing of responsibility that happens, or the objectifying and blaming of the victim that a respondent might be engaging in. And don't pick up that language yourself. It's very natural to sort of mimic language that we hear. So be thoughtful about the language that you're using. Don't use consensual language if your client is using non-consensual descriptions. You know, if she's saying, or if he's saying, or if they're saying that, they were groped, or they were forced into, he forced his penis into my mouth, or he grabbed me. Don't use minimizing language or consensual language yourself. And then always remember that an assault occurs because of an actor. So don't turn this into an invisible perpetrator where we just remove the offender completely, the respondent completely, and say, well, she was sexually assaulted. No, she wasn't sexually assaulted. He sexually assaulted her. So be paying attention to your language there. Also, another consideration related to before you get to the hearing is continuances. And often a response that we get is that, the respondent's Fifth Amendment privilege is something that the court really needs to consider and continue this case until the criminal case is resolved or until the criminal investigation is done. But the fact is that there's actually case law that identifies how civil and criminal case, a civil protection order case should not rely on how a criminal case is proceeding. And these are the 8 factors that a court is supposed to balance in determining whether or not a continuance should be granted in a protection order. And then the final hearing. Sarah, you want to take this?
Sure. So the court procedure, it just varies. It absolutely depends on what court you're in, and then what judicial officer you're in front of. So I think Rady had mentioned before, being thoughtful and strategic about where you file your case if you have experience and knowledge in terms of the judges that you're going to be in front of. It can range from the court making its determination based solely on the written pleadings submitted and your oral argument, or requiring what amounts to a mini trial. So talking to some folks ahead of time, either practitioners or even speaking to maybe the judge's bailiff to get an idea of what that final hearing is going to look like is really important, both for you and your client, so you can prepare them as best you can for what to expect. Again, the rules of evidence need not apply, and that's Evidence Rule 1101. So other than with respect to privilege and the Rape Shield Statute and ER 412, if a couple things about the Rape Shield Statute, if the petitioner, if your client wants to bring in evidence of their past sexual history or lack thereof, then that will open the door to allowing the respondent to bring in evidence regarding that as well. Assuming your client is not opening that door, if the respondent wants to bring information like that into the case, they have to file a pre-hearing motion, and their in-camera review of what respondent is wanting to present is required. Civil Rule 81, again, limited application of civil rules and special proceedings, and these protection order processes are special proceedings. And then during the hearing, again, always wanting to maintain client-centered, trauma-informed practice. So you want to collaborate with your client and their advocate before the hearing to ensure that it can be as the least traumatizing, the least damaging possible. If there's a full docket, you can ask to have the hearing at the end. Our experience is most judges will do that anyway, which is helpful. You can have your client wait elsewhere until the hearing is called, perhaps one of the little meeting rooms outside of the courtroom. They can go with their advocate to another area of the courthouse. They don't need to sit in the courtroom where the respondent and his family or supporters likely are waiting for their hearing. When you are in the courtroom, be cognizant of your client being near the respondent, being able to see or be seen by the respondent. You can ask at the end of your hearing that the court require the respondent to stay for a few minutes after you leave. Again, just minimizing the risk of any sort of interaction or even encounter with the respondent. And a lot of these kind of apply to non-COVID times when we are in the court, when we're actually in the courtroom with our clients handling these cases. But some of them can apply now in terms of being remote. You can talk to the court about your client's camera being off unless they are required to give testimony or appearing by phone. So again, just working with your client and their advocate, if they have one, to just establish some ways that the hearing can be less harmful, have less of a harmful impact on your client.
Last month, we talked about remote hearings specifically, and one suggestion we had was, for example, if your client has to keep the camera on or has the respondent on video, for example, maybe putting a Post-it over the respondent's face so they don't have to look at the respondent's face. So there are things that you can be doing to really try to still make the remote process trauma informed as well. So unlike the anti-harassment order and the domestic violence protection order, the sexual assault protection order statute is a mandatory grant if there is a finding of non-consensual sexual conduct. So a single act, there doesn't have to be multiple times of multiple sexual assaults, just a single act of a non-consensual, any sort of sexual assault that meets the definition is sufficient for the entry of an order. And there's also, the statute lays it out, a couple of reasons that the court actually can't deny the protection order. And it goes back to victim blaming. So it can't be, well, now the victim is not afraid of future danger from the respondent. The focus is the sexual assault itself. It's not about future fear. It's about the sexual assault that they experience and the trauma. Being a minor, in the past, often the language of boys will be boys was used to really diminish the experience of teen survivors, young survivors. So the fact that somebody's a minor is not a basis for denying a protection order. Recognizing that a lot of survivors don't want to make a report to law enforcement, and that a lot of sexual assault, it's coercive, but there might not be obvious physical injuries, like maybe the traditional ideas of sexual assault used to be, where there's torn clothing and like bruising, because the survivor fought back. Because we often know that survivors don't fight back if they feel like they're in danger, and there are different responses to fear that survivors have. Intoxication, voluntary intoxication, is not a basis to deny. Just because somebody drank and then they were sexually assaulted, it is not the survivor's fault. And then often consensual contact can then turn into non-consensual assaults. And so recognizing that because maybe there was consent in the beginning, it is not ongoing. Consent needs to be clear throughout any sort of sexual contact. So initial consensual contact is not a basis for denial. Closing arguments, really focusing in on the definitions of the sexual assault itself, and how what your client experienced meets the definition is really important. We always like to draw the court's attention to the legislative intent language too, because we think it's so strong. And reminding the court that protection orders are meant to be protective. They are not punitive. Unlike the criminal system, the civil order is really about what does a survivor need to feel safe and to avoid contact. And the limitations on a respondent are pretty minimal. It's usually limiting them from places that the survivor has access to. And then address the thorny issues head on. If it's been several months or even several years, it's better to address why now the survivor is seeking the protection order. Be clear about the consensual act, if there was any consensual sexual contact before, if there was intoxication. And often we see survivors communicating with the respondent after the sexual assault. Share that information. Don't try to hide it, because often if you can educate the court on how trauma works, often we see survivors who are still trying to tell themselves that there's no way this person I trusted would have sexually assaulted me. Maybe if I just talk to them, they'll explain to me like it wasn't what I'm thinking it was. And so you see communication that will happen between a survivor and a respondent. It's better to share that instead of trying to hide it, because then it looks like the client, the survivor, is not credible. And then really highlighting the survivor's experience in their own words and the sort of aftermath, the trauma that they've continued to experience because of the sexual assault. It's really important to bring all of this up in your closing argument. And back to being trauma informed, this is where we also, instead of focusing on the survivor's behavior, we also want to focus on the offender's behavior, the respondent's behavior, and how they try to isolate maybe the client, how they ignored how your client was saying that they weren't consenting, how they tried to minimize when the client was expressing fear, making sure that you're using the survivor's voice. And this is also an opportunity to really educate the court on sexual assault. Often the most the court gets experience, a lot of courts, they get exposed to sexual assault in the criminal context. That conversation is very, very different because the victim plays such a small role in the actual case itself. A civil protection order really allows a survivor to be able to share their story the way they want it shared. So it's an opportunity for the court to hear directly from survivors who've experienced serious trauma. And then what happens? Now you have a court decision. I know we're running over, but we're almost done. And this is why we actually cushioned it with an extra 15 minutes just in case. But now you've made your closing argument. The court is about to make a decision. Sarah, take it away.
Yeah, so now what? So it's going to go one of two ways, right? Hopefully it's going to go like this. Your order is granted. So if the order is granted, you want to review that order thoroughly with your client, make sure they understand the protections that are in place, make sure they understand that if there is an attempted violation of the order, that's a call to law enforcement, because violation of the protection order can be a criminal offense. We also like to talk to our clients about who they may want to provide copies of the orders to. If it's a minor client, perhaps their school, perhaps, or an adult client. If it's perhaps school, perhaps an employer. Obviously, again, there's always this weighing the need to provide the order to other parties and also having those parties aware of what's going on. So that's a decision for your client. And then we also advise that ideally the client is going to have a copy of that order with them at all times. That's probably not very practical. So having them take a picture on their phone of at least the front page of the order with the caption, so that if they have to report a violation, they've got the cause number on the order and they can let law enforcement, give law enforcement that case number and help facilitate that report being made. You can also make them aware that there's potential post-hearing litigation options for the respondent. So there are motions to modify or terminate, and there are some limitations in terms of how often those motions can be made by a respondent. Either party can file the motion, and there isn't really a deadline for those motions to be filed. There can be a motion to renew the order at some point. That order, unless it's a lifetime order, is going to expire, and your client may want to have it reissued by the court again. So you want to file that motion to renew within 90 days before the expiration date. I won't go into detail about it, but it's important to look at the statute regarding renewal. A nice thing is the burden in that hearing really shifts to the respondent, in that case, to show the court why the order should not be renewed. Now, also, it's possible that the order will be denied. If the order is denied, the court needs to state in writing why that order was denied. The court isn't obligated to go beyond checking the box that says preponderance of the evidence was not presented to establish a sexual assault occurred. Case law has said that that is sufficient, but sometimes the court will go beyond that in terms of their reason. Regardless, they do need to state in the written order why they denied the order. Options for your client at that point. Typically, SAPOs are being heard in front of judges. I'm not sure that a commissioner can hear a SAPO. Maybe I would, Reedy, I don't know if you want to touch on that, but if a commissioner were permitted to hear a SAPO and issue a final sexual assault protection order and they denied it, then you could file for revision, which is having a judge review the evidence de novo. The deadline for that is 10 days from the date of the order. There's a motion to reconsider. That's essentially asking the same judge who denied the order to look at that again and hopefully change their mind and acknowledge an error was made. And then there's an appeal, and that is obviously a more complex and lengthy and expensive option, but it is an option. There's a 30-day deadline for that, for the notice of appeal. So those are things that you can discuss with your client as well.
And related to your question, Sarah, yes, commissioners can actually hear SAPOs, not all counties. For example, in King County and Pierce and Thurston, not Thurston, in Snohomish County, I know commissioners focus on the family law docket and the DVPO, but there are other counties that we've been in where commissioners are also designated to hear SAPOs. So this is where it also goes back to individual jurisdictions and paying attention to what the process is in the county that you're filing. Just some final considerations. So 1 in 3 women are going to experience sexual assault in their lifetime. 1 in 6 men are going to experience a sexual assault lifetime. 1 in 2 non-binary individuals are going to experience sexual assault in their lifetime. And actually, if you have a disability, then that number increases significantly, or the numbers related to child sexual abuse, I'm not even going to go into how high those are sometimes. But this is why it's also related to, back to our ethics credit, be paying attention to working with clients with diminished capacity. RPC 1.14 exists to provide guidance, but in the end, it really is about making sure that you are still engaging with the client and treating and really listening to the client, unless it seems like the client is not able to really provide feedback or advice or consult with the attorney. And so I really want to draw the language to that the attorney is obligated to take steps to maintain normal lawyer-client relationship, even when the capacity might be diminished. And an aspect of this to also keep in consideration, to keep in mind, is that sometimes, because sexual assault is about power, it is about asserting control over a survivor, that often we are engaging with guardians and caregivers and support people who are also there to support survivor, but a child survivor, a survivor, adult survivor with maybe diminished capacity, do pay attention to if the caretaker, that friend, that parent that is showing up for the survivor, how much they're actually trying to direct versus allowing you to engage with your client, and how much are they trying to control the process. Some of it can be protective, but if it really is about diminishing the survivor's voice, this is something that you want to be paying attention to. And so some examples can be where they're excessively controlling. Maybe they're we've seen maybe cases where parents are really upset about who their child is dating, and then they're really focused on if a sexual assault protection order should apply. But then when we're talking to the teen themselves or the child themselves, it's a different conversation. We've also seen cases where maybe they're supporting the offender. We've had cases where mom is supporting abusive boyfriend and not believing daughter, or father is really supportive of his best friend and not believing the children. So we've seen examples like that. So be paying attention to that. And then of course, not often, but in these cases, sometimes the parent or the caregiver is the offender themselves. So another consideration. Financial, another RPC to keep in mind, because we're talking about pro bono services. Just a reminder, most of our clients, nearly all of our clients are indigent. And as much as you may want to be able to assist them financially, under 1.8E, Washington has not adopted the model rules, the ABA model rules around being able to provide financial assistance to indigent clients. We appreciate your generosity, but you cannot be financially assisting an indigent client related to representation. In the end, the client has to be able to cover those costs. This is where it also really helps working with advocates, because a lot of times their programs have the ability to provide assistance. And then last thing, sometimes it's not all often, but often there are times where we just know that a judicial officer is just not going to grant a protection order regardless of who the survivor is, because they just don't believe sexual assault occurs that much, or just based on comments that they've made in previous cases, that they're automatically going to assume that the survivor is lying, or because alcohol was involved, they don't think that it's the respondent has any blame. So in cases where you may be aware that the bench that you might be, the judicial officer you might be in front of might be biased, just a reminder that you can disqualify a judge, but you can only do it once. This is not about cherry picking who do you get to be in front of. This is really about trying to make sure that you don't end up in front of a biased bench. And so definitely look at your local rules, and this is the citation. And that's basically it. I think we're at time. We have a Jamboard. I don't know how many folks are still on here, but I will share it. Or did you share it, Yvonne?
I tried to go to the link and it was view only, so I wasn't sure, but
Okay.
I'll share it right now, just in case
If it
it's
doesn't,
accessible now.
if it doesn't work, actually, let's just use the chat feature then. Are there tips that you found helpful, or are there tips that you want to share with the group before you go that can help all of us who are interested in representing survivors?
I do see people joining, so
Oh, okay.
maybe only I can view.
Then I will
wait.
go back to the Jamboard and see how it looks. Where is it? Okay, so for anybody who has used this before, on the left-hand side, you'll see there's a little Post-it sticky note icon in the middle. And so if you click on that, you can actually create a Post-it sticky note. And we won't know who's writing, but it's a chance for you to share tips that you found helpful, or tips that you would like to share with the group that you think
If we don't have access, like if it's saying that it's view only, do you want us just to post it in the chat here?
Oh, is it saying view only for everyone? Okay.
Yeah.
I don't know how to edit this right now. Yes, please put it in the chat. Thank you for that, Holly. And then Yvonne, do you want to read a few back? In that case, I'm going to stop sharing this screen.
Yeah. I'm gonna write down what the Jamboard prompt was.
And I know that's actually, we're way past. We had set it for 1:15 just in case, and we're at 1:20. So I know folks have to go, but for folks who do have to go, thank you so much. For folks who want to stay on and keep talking, we have a little bit more time for ourselves to answer any questions that you have. And also, if you're interested, our next CLE is going to be a month out, and we're looking at language in the courtroom around sexual assault. Also, with the PowerPoint, you are going to see our contact information at the end. So feel free to reach out to us with any questions that you have. If you need technical assistance, if you want to talk through a case, or if you're interested in volunteering with us in SABA, we're excited to have you. So hopefully that gives also folks a little bit of time to add any final thoughts that they have in the chat.